Thank you. So we decided to talk about this because I do literally every area of labor and employment law except for workers' compensation. So I know absolutely nothing about workers' comp. And I'm sure there are plenty of workers' comp practitioners who don't know a lot about employment law. And there are often issues that are intertwined when you're representing either folks in an employment situation or folks in a workers' comp situation where it would be helpful to at least be able to issue spot the other issues so that you can either try to handle all of the legal issues, or what I do is refer them to people like Taylor or Brad or somebody who actually knows what they're doing when it comes to workers' comp. So we're gonna cover three areas that are often interrelated in workplace injury issues for employees, and that will be the Family Medical Leave Act, the Workers' Compensation Act, and then the Americans with Disabilities Act. We're just going to give you a quick highlight of some of the applicable provisions of those three laws, and then we're going to have some fun in the afternoon and show you how to issue spot from fact patterns some of these issues. So, starting with the Family Medical Leave Act, that law only applies to employers who have 50 or more employees within a 75-mile radius. In order for an employee to be entitled to family medical leave, they have to have worked for their employer for at least 12 months and have worked at least 1,280 hours. FMLA entitles you to take up to 12 weeks of medical leave for either your own serious health condition or a serious health condition of a immediate family member. There's also some other provisions that don't necessarily relate to the issues that we're talking about. It's non-discretionary leave, meaning the employer can't discourage an employee from accessing their family medical leave, and it cannot be used against an employee. It also gives you protected job status in that if you take your family medical leave, you are essentially guaranteed to be able to return to your same position or a position with equal pay and benefits and stature. There are some specific notification requirements. The employee is supposed to give as much notice as is reasonably possible to an employer for the need for family medical leave. 30 days if it's something that's foreseeable, if you're going to have a surgery that's planned. Obviously, there are a lot of serious health conditions that sort of arise out of an emergent situation. And the employer only has 5 days to inform an employee who either tells them of a serious health condition or for which they just have facts that would lead them to believe that the employee may have a serious health condition which would entitle them to access their family medical leave. Family medical leave can run concurrent with paid leave benefits, and this is a decision that the employer is entitled to make. So an employer can tell its employee who's going to take unpaid family medical leave that you have to use your accrued paid vacation or sick or PTO time while you're out on FMLA leave.
Just going to hold this. Okay, so the workers' compensation statutes in Idaho, obviously we're dealing with employees who are injured on the job. It's a statutory requirement that most employers in Idaho carry. There are some very, very limited exceptions to that. The ones that are commonly referred to as exceptions are like ski patrol volunteers or crop dusting pilots. So by and large, most employers are required by law to carry workers' compensation insurance. The employee becomes eligible for the workers' compensation benefits if they are injured on the job as of right when they start work. So they could be there for 5 minutes, and if they're injured, then there should be coverage for them. The other requirement is that the injury has to occur within the course and the scope of the employment, and that's an issue that's litigated a little bit more than you might think. And I'll just give you an example. Last year, the Supreme Court heard a case of a guy here in Valley County who's down in Cascade who hurt his back tying his shoe on the job. And there's a lot more facts that go into it, but that's kind of the essence of it. And that one of the biggest litigated issues in that case is whether or not that was within the course and scope of the employment. So the workers' compensation statutes are designed to provide medical benefits for the injured employee, as well as time loss replacement and income for the injured employee. The employee must provide timely notice of the injury. Typically that's 60 days from the date of the injury, and the employer must report the injury to the Idaho Industrial Commission within 10 days, and that's via a first report of injury. These forms are all on the Industrial Commission's website. One of the, unique things about workers' compensation law that I think a lot of the people who would call your office don't understand is that workers' compensation laws in Idaho do not provide any recovery for pain and suffering issues, loss of consortium, that kind of thing. The Idaho Industrial Commission has exclusive jurisdiction over the workers' compensation cases, and generally if you lose in front of the Industrial Commission, you're appealing straight to the Supreme Court. So that's the gist of our workers' compensation laws.
Okay, and finally, the ADA, which was a discrimination law passed in the 1990s, and then essentially gutted by a series of circuit court and Supreme Court decisions. And then finally, Congress got fed up with it and fixed it by amending the act to make clear their original intent and restore what the ADA was originally there for, which was to protect people from being forced out or not hired into the workplace because of actual or perceived or a record of disability. So as of January 2009, you can actually bring these cases again. It applies to employers for the state law provision who have 5 or more employees, for the federal provision, 15 or more employees. It provides for very broad protection of people who have an actual or perceived disability, and this can be a mental or a physical disability, have a history of a disability, so perhaps have had cancer that is now in remission, but they have that history, or actual perceived history. What am I missing? Is that it? That's it. Okay. And it prevents employers from making decisions in hiring, firing, promotion, pay, also hostile work environment issues. A physical or mental impairment has to substantially limit a major life activity. However, after the January 1, 2009 amendments went into effect, that's a much lower hurdle to cross. So even though substantially says substantially, it doesn't have to be significant or complete limitation of a major life activity, which are things like, walking, sitting, lifting, driving a car, care for yourself. It can be things like breathing, if you have a disability that impacts any of your internal functioning of your body. All of those things are now considered to be major life activities. And it requires an employer to provide, if necessary, reasonable accommodations to the extent that they don't cause an undue burden on the employer. And that's something that is going to be different depending on the employment situation, the employer, the disability at issue. But some of those accommodations could be a leave of absence to obtain medical care or treatment, modifying a work schedule, actual equipment or changes to the work site, and ADA leave as an accommodation, which is probably something that would be intertwined with these workers' comp issues, can run concurrent with both family medical leave and workers' comp or other paid leave. So now you have sort of the broad overview of these 3 laws. We're going to open up our law firm here for business.
You guys need me?
You have to come into the law firm.
Oh. Start back over here.
how are you?
Good, come on in, have a seat.
Oh, all right, thank you.
We have some leftover tea or water if you like.
Good. Thanks.
Oh, I see you have a wrist guard on. Is everything okay?
Well, I got hurt at work several weeks ago, and I just had some questions about what I can do, and just not really certain about what's going on.
What was your job?
Well, I work at Good Eatin' Foods as a relief forklift driver and like a freight clerk. So I work moving stuff around, freights, and with this business. And
Do you know how many employees they have?
well, there's 2 spots, one in Twin Falls and one in Jerome, and I believe both have about 35 employees. Rough estimate, 35.
Okay.
Tell us about the injury. How did you hurt yourself?
Well, I was going into work, and we clock in and clock out, so I was walking in to clock in and get started in the morning, and I slipped and I fell and landed on my right arm, and I'm right-handed, so it's pretty difficult to do a lot of things with this brace on, and so I slipped and fell and hurt my arm, and immediately went over to my supervisor and said, hey, I just fell down, and it's hurting real bad, and I don't think I can stay at work today. And he's like, okay, why don't you just go home and take some Advil and put some ice on it. So that's what I did.
So they didn't give you any forms to fill out?
Nope. He just said go home and basically rest up and it'll be fine the next day. But the next day I called in, and my arm was hurting more, and he said that just keep taking another day off. So I'm using my sick leave now, and it's just he said keep icing it, keep it at Advil. So this went on for a full week, and Monday I called in and I'm like, look, doc, Bob, his name is my supervisor's name is Bob. My arm's still hurting real bad, so I'm going to go to the doctor. So I went to the doctor on that Monday. So that was about a week after the injury, and the doctor did an X-ray, and sure enough, my arm was fractured, and they casted it up and told me I needed to take 6 to 8 weeks off from work. So I told my employer this, after they cast it up and I got home, and he said, well, let's not report this right now because it might affect your ability to get your bonus. And so I was, it started making me think something weird was going on, and I wasn't sure. And then I'm taking my time off, and a workers' comp person comes around to take a look at my arm, and
You mean a workers' comp doctor?
I think so. Workers provider or someone, I don't remember.
Okay. Did you know if your employer ever told you about this workers' comp position prior to you going?
I don't recall.
Okay. So what did that doctor tell you?
Well, so this was about 2 weeks after they casted me up, and this guy says that I should return to work and do light duty, one-handed work. What? Go ahead. What?
Oh no, I was just shaking my head.
Oh, all right. Well, yeah, so it was 2 weeks after, and he said one-handed work, and I'm just thinking about most of the stuff that I usually do. It's not usually one-handed. And plus, the doctor said 6 to 8 weeks, and it's really only been 2 weeks.
Okay.
So I'm just kind of wondering what's going on. I don't want to. I'm worried I might lose my job if I don't go back. And
do you know? Does the employer have any light duty work that you could do one-handed? that you're aware of?
They might, and just maybe some desk stuff, but they usually have other people doing that, so I don't know.
Okay. Did anyone talk to you about offering family medical leave?
Nope.
No. Okay.
With your current job, if it was considered light duty, do you think you could do it safely one-handed?
You know, that I'm just not sure right now. I mean, I haven't done it, so I mean,
You're driving a forklift, right?
yeah.
You
Because
think
that's
you
my normal job,
Yeah.
is driving a forklift, and I don't think I'd want to drive a forklift one-handed, and I don't think people around me would want me driving a forklift one-handed.
could- How long have you been working for It's Good and Eats?
Good eating food.
Good Eating Foods.
Mhm.
Like it.
I've been with them for 6 years, I believe,
And full time?
full time.
Okay.
And I've always, it's 6 years. I've always had solid work performances. I've never had any problems performance-wise. You probably ought to know this, but I have filed. I think this will be potentially would be my third workers' compensation claim. So I haven't filed anything here specifically that I recall.
Were your prior injuries serious, or were they
Nah, they were pretty minor. This is definitely the most serious. The other ones were just quick little things.
Have you had to take time off work in the last, say, 12 months for an injury or illness?
Well, prior to this, no.
Okay. Okay.
all right? I don't think I have any questions for you. Any other questions? Do you?
I don't
Erica?
think so.
Okay. Well, Erica, what would you advise Mr. Weeble Wobble?
Well, you're probably going to have to be the one to give him advice about this light duty return to work issue. But as you may have picked up if you were paying attention to our original presentation, we were focused originally on trying to find out how long Jeremy had worked for his employer and how many employees that they had, so we could figure out if he's got any rights to take FMLA leave, which again gives him protected job status in that he's insured to be able to return back to his former position. And he told us that they've got 2 sites, one in Twin Falls and one in Jerome, both with 35 employees. So he would meet the threshold 50 employees within a 75-mile radius. He's worked there full-time for 6 years, so he's going to qualify on that eligibility ground. And it sounds like the employer hasn't given him any notification of his right to FMLA leave, which is a violation of the law. So I would probably advise him to inquire with the employer to get that leave in place, because again, that gives him some protection about returning to work. And we could deal with the fact that they didn't timely notify him on the back end if necessary.
We also were kind of focused on when and where this injury occurred. Obviously, he said that he fell and hurt his arm when he was walking into work. I think he said putting in his time slip. In the workers' comp system, when an injury occurs on the employer's premises, there is a presumption that the injury arose out of the course and scope of the employment. This is obviously another kind of more litigated issue when there's questions about that. It's not always that clear that you are on the employer's premises if you're traveling to work or from work. Those are generally exceptions to the rule, but if it's, for example, you have somewhere that you normally park and then you have to walk across the street, and there's rules about ingress and egress in that regard. But those are a little bit more litigated. In this case, it's pretty clear cut. He was on his premises at the time. So, and the fact that he'd been there for 6 years has no implications for me. Like I said, if he was there for 5 minutes, he should be covered. So,
What about the fact that the employer sounds like discouraged him from reporting the workers' comp?
right, employers have a duty to file a first report of injury with the Industrial Commission within 10 days of the actual injury. So if they're not doing that, then that's a violation of law. What I would usually encourage employees to do if the employer is dragging their feet in this regard is just do a notice of injury on their own straight to the Industrial Commission. That gives the Industrial Commission notice. It also gives the surety that should be covering the case notice. And this unfortunately happens to employees more often than you would think it should.
Can I add?
Yeah,
add
please.
and just see what you guys do with it. So what if his, complaint is a couple weeks after, he's missed work because he's getting medical treatment. His employer starts making comments to him like, you're lucky we treat you this well, because a lot of employers would just get rid of you because you're on workers' comp. They would insinuate that. And then let's say he further tells you that not only that, but I've always been a really good employee, and suddenly I get in trouble all the time.
Yeah.
And I got to tell you, I don't think I'm doing anything wrong. And I guess we take one step further. Let's say he loses his
Right.
job. Who's bailiwick?
Yeah, so it's funny, you were not planted, but I was just going to talk about that issue. It's something we didn't put on the initial list, but it violates public policy to terminate an employee or retaliate against an employee for accessing their workers' comp benefits. So the fact that his supervisor is saying, hey, you might not get your bonus if you file your workers' comp claim, and if he comes back to the workplace or they fire him, or if he comes back and is mistreated, those are the kind of facts I would want to be pulling out of him to be able to make a decision about whether or not I think he has a wrongful termination and violation of public policy claim.
But
Absolutely.
in that context, what kind of remedy do you have against the employer? I mean, if it's a $1,500 bonus, do you get fees in a way that makes it financially plausible to pursue?
Yeah, you can. So your attorney's fees are compensable for wrongful term and violation of public policy claims. But if it's a denial of a bonus issue, the wrongful termination claim isn't gonna kick in. So it's got to be a termination in order to trigger the wrongful termination claim. And we see this, and usually you're looking for a broader pattern of an employer who is consistently discouraging or mistreating or later terminating employees who access their workers' comp benefits. So we had a huge case out of Salt Lake against Lazy Boy where they were terrible with handling their employees' workers' comp claims and would either essentially force them out of the workplace or outright terminate them after filing. So we had a multi-plaintiff case.
Erica, is the fact that the doctor took him off for 6 to 8 weeks important to you?
So obviously we talked about the FMLA leave would kick in for the 6 to 8 week period. Even if this had been a situation where he hadn't worked for up to a year or they didn't have 50 or more employees, he would potentially, if he were considered to be disabled, which a disability under the ADA does not have to be something permanent, could access as a reasonable accommodation medical leave to have coverage for that and the same type of job protection that the FMLA would provide.
And under the, go ahead, Robin.
So can, let's say you exhaust your FMLA, I don't know, because you've got an injury that's gonna take a while to heal or whatever, so you exhaust your FMLA. Can you argue that, under the ADA, that he should have another 4 months?
Yes. And that's usually when we're using the ADA. Either they don't qualify for FMLA for these eligibility reasons, or you're going to get past that 12-week window. What you need is the physician to be able to give a reasonable estimate of time. You can't just go to your employer and say, I need more time, without giving sort of a time frame for how much time you think you need before you can return to work. And then the issue becomes, is that extended leave going to be an undue burden on the employer? And if it's a small employer and you hold one of the primary positions, it might be an undue burden. But if it's a big employer where they have lots of people to cover your position, it's probably not going to be an undue burden and you're entitled to that extended leave.
And the ADA will protect your position?
Well, to go back to your position, yeah, I mean, it's not written the same way that FMLA is written, that you're entitled to go back to your position or one of equal benefits and stature, but yes, I mean, the ADA says you can't discriminate against someone for having or asking for a reasonable accommodation. So if you go back and they say, oh, sorry, you're now going to have this menial job, that would be a clue that you may have a discrimination issue under the ADA.
But to ask for the FMLA, or to ask for the ADA, you better have a set time frame that you're...
Yes, we have our folks go meet with their doctors and have their doctor say, I'm I have a follow-up appointment scheduled on X date. I'm anticipating that I'll be able to return him or her to work at that time. Some good estimate, reasonable estimate of a specific length of time, as opposed to just I need more time and I don't know how much.
I see, so the employer can be reasonable or
Yeah.
undue burden.
Right.
And from the workers' comp standpoint, the time off is important because the injured employees are not paid their time loss benefits, often what we call TTD benefits, for the first 5 days of being off work or disability from work, unless the disability exceeds 2 weeks. So that's important in this case. Another thing to consider, I get calls all the time from people who are injured on the job, and it happened 3 weeks ago and they still haven't seen their time loss benefits. Well, under our statutes, the sureties have 4 weeks to pay those time loss benefits. So the employee is out for 4 weeks without an income. And usually TTD benefits are paid at 67% of what the injured worker's average weekly wage was. Some complicated formulas can go into that system, but that's typically how it's paid.
So in this situation where his doctor has said you've got to be off for 6 to 8 weeks, and then the workers' comp doc says, you can go back to light duty, but he feels it's not safe, where would that leave him with the workers' comp?
So there's a couple issues that Jeremy raised for us. First of all, employers do have a requirement to inform their employees of a company physician. Doesn't sound like he was given that information, so that's a violation for the employer. We do see disagreements all the time between the physicians that kind of work for the employer surety and the treating physician that the claimant goes to. In this situation where we have one doctor saying that he can go back and do light duty, if the employer has light duty that is available and fits within the restrictions, and I usually make sure that the physician knows or is generally aware of what the actual job duties are before we just allow him to return to that position, potentially putting himself and others in harm's way. I imagine in this situation that if the physician knew that he was driving a forklift, I don't know of a light duty forklift job out there, but if there was something behind a desk that he could do with one arm safely, then I would encourage him to go try to do that. And in fact, the law says that you probably need to do that, or you would risk losing your benefits.
And under the FMLA does not necessarily entitle you to light duty work. You can use your FMLA intermittently, so you can use it to work less hours in a day, but it doesn't have any entitlement to changing the actual functions of your job, nor does necessarily the ADA, although a reasonable accommodation may come into play. So if there's an employer who has the ability and offers light duty work to other folks, they can't deny that because you have a disability issue. They have to treat that even-handedly. Is the number of workers' comp in these prior cases at all impact his current workers' comp?
No, the only thing that could potentially come into play is if you end up litigating the case and you see that the employee has a long history of complaining of really small things and taking off, work for things that maybe really didn't deserve that. Then it could potentially affect his credibility. But for these benefits that we're talking about right now, the TTD, time loss benefits, and the medical benefits, it's really not a consideration for me.
And it's important from my perspective to sort of do two things. One, to figure out if he's taken any potentially FMLA leave within that 12-month window, because you only get 12 weeks every 12 months. But also for the potential wrongful termination claim. Employers sometimes will tolerate 1 or maybe 2 workers' comp injuries, but if you get 3, you're out the door. And so if there's a pattern where you have somebody who's had 1 too many workers' comp claim and is getting terminated for that raises the wrongful termination issue. Yes.
Now, does the ADA apply to getting a job as well as staying on the job?
Yes. Hiring.
This may be beyond your presentation, but does that make it harder to prove that someone who is unable to return to work because of an injury is going to be unable to get a work job? I mean, do defense people say, well, given the ADA, they can't compel someone to make accommodations when they're applying to a job?
I don't know if I understand your question. Are you asking, does the ADA require employers in hiring to
Yes.
get? Yeah, so employers are not supposed to ask about disabilities, obviously, in the hiring process. They can ask, which is essentially asking if you have a disability, if you would require any reasonable accommodation. Now, they're not supposed to hold that against you. So if you say, yes, as a matter of fact, I am going to need a reasonable accommodation, and here's what it is, their legal duty is to not factor that into their hiring decision, and if you're hired for the position, to provide you with that reasonable accommodation.
Are there fairly clearly established precedents on how much accommodation is reasonable versus not?
There's lots and lots of case decisions, but the problem is that it really depends on the employee's position and the company as to what's reasonable, because, bigger employers may be more easily able to absorb whatever the accommodation is versus smaller employers, or vice versa. I mean, just because you're a big employer doesn't mean providing accommodations is going to be, but it's very fact intensive. And so there's a lot of litigation over that issue. And I think it's an area that employers tend to mess up often. They have a duty once an employee comes to them and says, I have this disability and it's impacting my ability to do my job, the ADA says you have to sit down with your employee and engage in this interactive process discussing how you can provide a reasonable accommodation to them. And employers often they either don't recognize that obligation or they ignore it and get themselves in trouble.
Can an employer mandate that an employee get medical treatment for a condition?
Under the ADA, there are very strict guidelines in place for when you can send an employee for a medical evaluation. You can do it at the beginning of a job if you have sort of a plan in place that applies to all employees that are being hired for a specific position, and it relates to your ability to perform the essential functions of that job. So, firefighters may have to complete a physical or things of that nature. If it's an on-the-job injury, under certain circumstances, they can require you to go through a fitness for duty examination before you return to work, if they have legitimate concerns that you might not be able to return to work safely. But those circumstances are pretty rare, and the medical inquiry that they can send you to has to be specifically limited to finding out if you're medically able to perform the essential functions of your job. So they can't be digging around for other information or issues about your medical condition or other potential disabilities. That would violate the ADA. And I don't know if workers' comp.
From a compliance perspective, if you have someone who's not complying with the medical treatment that's being recommended, they could risk losing benefits. But I don't think that there's anything under the workers' comp statutes that require, or that says an employer can require an employee to undergo medical treatment.
I'm just wondering if an employer, for example, has a hint that maybe somebody's got some kind of mental health issues going on or something like that, they can say, well, you need to go over there and get some help, and if you don't, you're on.
It's an objective standard, and they have to have specific evidence to suggest that this whatever is going on with the employee, whether it's mental health or physical issues, is impacting their ability to safely work in the workplace. And so it's a pretty high burden for the employer to meet, but if they can articulate those specific facts based on objective evidence, not just their subjective belief that there might be something going on with somebody, they can require a medical inquiry. Okay, hopefully that advice was helpful to you, Jeremy. Thanks for coming in.
Yes, thank you.
Careful going up the steps.
Uh-oh. Come on in.
Ladies. Hi, it's so nice to meet you. Please shake my elbow. Thank you.
Hi, what's
Hi.
going
My
on?
wrists just kill, and my neck. Oh, I can't.
Oh,
Well, come on in
Really?
and have a seat.
Okay.
Can you get up?
Sort of. Okay.
careful there.
I want you to know that I've never ever been to a lawyer before, but I heard the two of you are just the very, very best, and I know that you will take great care of me, and I'm super nervous.
Oh, don't be nervous.
I'm really, really nervous. I've never ever thought about suing anyone, but I know that you guys will take care of me.
Well, what's your name?
Wendy Walmart. WALLMAHRT.
Okay.
Walmart. I know it sounds like Walmart, and it's sort of weird because I work for this place called Big Box Inc. And I do customer service, and it's sort of like Walmart. It's weird.
That is weird.
What was your job for them?
Well, I was doing customer service.
Don't fall off the back of the stage.
And I was, you know, you're on the phone all day long. And your phone, they never gave me a headset. So I had to have the phone. And then I had to type all day long like this.
Aye.
And I'm on the phone all day with these people. Oh, these people. They were just so mean. You know, you try to be nice to them, you try to take care of their problem, and all they want to do is yell at you all the time. You got to take back these snow tires, they blew up. You charge me too much for this Chinese t-shirt that has a big old hole in it. Like, they just yell at you all the time. And so I was really having a hard time with that. And other people had a hard time with it too, other people in the workplace. But they did other things for people. Like, Rojani talked to our manager, Carmen, and he got this great headset. So he didn't have to hold his phone like this anymore. But I never got one. I asked twice.
You did ask?
I asked, and they always denied me. I don't know, Carmen maybe didn't like me. But here's the thing. I had this person who I worked next to. He was a real jerk, Manny. And he was the one who would go to all the coworkers. First of all, he called me Wendy the Weasel. And he said that he went to all my coworkers and said that I was ratting them out to Carmen. I don't know if that's why Carmen didn't like me. But anyway, no one would talk to me. And they wouldn't have lunch with me. And it was really, really awful. And so meanwhile, I got all these people yelling at me on the phone about their snow tires. And then nobody will talk to me and nobody will have lunch with me. It was super stressful.
Oh, did you have to seek any kind of therapy or treatment or?
Well, I started having nightmares. And then I got really depressed. So it was hard to get up in the morning. It was hard to go to work, especially when all these people were going to yell at me, and then my coworkers didn't like me. But I still was going to soldier on. I mean, I'm a single mom. I had to provide. I have 3 kids. Like, I had to go to work. But then my wrists started. I mean, you know, I can't even shake hands. My wrists just were so hurting. Every time I'd have to go to type, they hurt. And so I talked to Carmen about it. I talked to her a couple of times, and she's just like, oh, too bad, so sad for you, take some iBu. That wasn't very helpful.
Yeah.
So then eventually she sent me to some doctor. I don't know why. So I went and I told the doctor pretty much what I'm telling you guys. And the doctor said, it's all in your head. And I said, no, it's not. It's in my neck. So I don't know. That doctor was not about helping me. That doctor was only about helping the company. And I think you know what I mean.
Know what you mean.
So ladies, what should I do? Oh, then after I went to the doctor, the reason I'm here, I wouldn't have even come to see you, but they fired me.
They fired you?
Yeah, no reason. Wendy, Walmart, you just don't fit in. And I had been working for the company for like 2 years. My customers, even though they were awful to me, I solved their problems.
So you didn't have any prior discipline?
Well,
Here we go.
I did sort of have a little bit of a problem. But it was because, you know, I told you about Manny and how he's so mean to me. So to get back at him, I cut the legs off his desk.
And you got in trouble for it?
Yeah, Manny told Carmen and she wrote me up.
Okay, when was that?
That was about a month ago.
Okay. No other discipline in between that time and your termination?
No,
No. Okay. And they didn't, the only reason they gave you was you didn't fit in?
I didn't fit in.
Okay. And it was a week after you saw the doctor?
That they canned me.
Okay. And have you...
They can't just can you for no reason, can they?
Well, you're in Idaho, so yeah.
What does that mean?
It's called at-will employment. And it means that your employer...
That
can-
wasn't my will.
Right, right. Well, they say it works both ways because you could quit at any time, but we obviously know how that
No employee
works.
is gonna quit a real good job.
Right.
It's just not gonna happen.
Right. Yeah, they can fire you at any time for any reason except for if it's an illegal reason, and I think you've raised some issues that we might want to get into.
You think it might be illegal?
I think it might be illegal. So tell me more
Good.
about your neck and your wrists and
Okay.
Your depression.
So, I wear this really nice scarf to cover up this very ugly neck brace that I started wearing about 2 months ago.
oh, okay.
And as you can see, I can't turn my head. It makes it super hard to drive.
Right.
What do you think that's from? Where did the neck injury come from?
I think it's from talking on the phone.
Okay.
That's when it started hurting at work, when I was talking on the phone. 8 hours a day, one direction, and then I sort of tried to switch to the other direction. Now my neck hurts in both directions.
So when you asked for to use the headsets, did you have the neck brace at that point in time?
No,
Okay.
I did not have. I thought I was hurting, but I could still turn. I could look around. I could drive my car. It was all okay. It was just hurting. So I thought, if I get a headset, that'll work.
Okay. And what about your wrists? Have you been diagnosed with like carpal tunnel or?
What's carpal tunnel?
Yeah, okay. Have you been to a doctor for your wrists?
Well, I told you Carmen sent me to that doctor.
I know.
And the doctor ignored the fact that I was saying my neck hurt, my wrist hurt. I did say the nightmares and that I was feeling pretty low and depressed. And he seemed like the doc just ignored the physical things that I had wrong and wanted to tell me I was just sort of crazy.
Okay.
I noticed that you're talking kind of loud. Do you have any hearing issues?
No, I was born this way.
It's called being from Chicago.
Oh no, I'm from Soda Springs.
Did you ever talk to your supervisor? Is your supervisor the one who fired you?
Carmen.
Uh-huh. Did you ever talk to Carmen?
Miranda.
Carmen Miranda. Did you ever talk to Carmen Miranda about the depression and anxiety from all this treatment by your customers or your coworkers?
Well, that's a touchy subject.
Yes,
I
know.
didn't want her to think I was crazy. But after a while, when she wasn't helping me, I pretty much just lost my cool and I said, this job is driving me crazy, Carmen, and I have nightmares and I can't get out of bed in the morning.
You told her that?
I did.
Okay.
It was humiliating.
Yeah, I'm sorry. Okay, well, we're going to work through your advice as our wonderful duo team.
Well, you guys are the best.
Virgin
so.
Hospital.
Okay, so do you want to talk about some of the potential workers' comp issues
Yes.
you see in there?
Absolutely. So she raised a couple different workers' comp injuries, her neck and her wrists. I would consider the fact pattern that she gave to be both what we consider to be an occupational disease issue. So under the workers' comp statutes, there's basically two types of injuries that they consider. One is, if you fall at work, break your leg, that's an accident or injury. The other one is an occupational disease, which is what we have here. That's an injury that occurs over time through repetitive motion, that you're doing over and over at your job. occupational diseases, at least in my experience, are much more difficult to prove under our current laws than just a regular old accident are. And I can read you what the law says. It says that a disease due to the nature of employment which the hazards of such disease actually exist are characteristic of and peculiar to the trade of employment. So you have to have kind of a job that's pretty unique, something that you're doing repetitively over and over and over again, that is really peculiar to that job. This one, I think that, if she had been there for a long time and was doing this all the time, and we have a physician's opinion that's actually saying, yeah, there's some damage to her neck and it's probably caused from doing this all the time, then, there might be some type of claim there. I think that just sort of historically, looking at some of the case law for carpal tunnel and typing, those cases are a little bit harder to prove, and generally doctors are a little bit more reluctant to give solid medical opinions on those types of cases. So what it boils down to is really what the medical opinions are in the case.
And what about the psychological issue?
So psychological injuries, the standard is very, very high in the workers' comp system. You need clear and convincing evidence that the psychological injury arose out of and in the course of the employment. So note that, clear and convincing evidence. It's a really high standard. Also, there has to be an accompanying physical injury. And so here we might have that established with the neck thing, but that's going to be kind of a vague issue. So you have to have a physical injury along with the psychological symptoms. And again, doctor's opinions that if she has any sort of iota of pre-existing depression, anxiety, nightmares, that kind of thing in her history, then probably not a case I'm even going to look at, just because it has to be clearly related to the occupation that she's doing.
And we see this in employment law all the time where she was being harassed by her customers and her coworker, but it didn't seem like that harassment was based on any of the protected categories under the discrimination laws, right? So coworkers and your bosses can't harass you if it's based on your age, your religion, your gender, your race, all of those protected categories. But if they're just harassing you because they don't like you for whatever reason, personality conflict, you wore the wrong color shirt, whatever, this kind of bullying in the workplace is not illegal under any of the employment laws.
What if they were giving me a hard time because of my neck?
Now, if they're teasing you based on a perceived disability or an actual disability, that could trigger protections. I mean, that you can't harass somebody because of a disability. But unless that were at issue, this kind of bullying in the workplace, there's nothing that we can do. And we see it all the time. We talk to people who experience this in their workplace and have significant psychological injuries. And so we're usually left with telling them, go and talk to a good workers' comp lawyer to see if they think there's any chance you could get a workers' comp remedy. Otherwise, it's really tricky to find a potential claim for those folks. Go ahead.
Erica, was there any requirement that Carmen should have given her a headset at some point?
So unless you are asking for equipment accommodation because of a disability, you're not entitled to have equipment that makes your job easier. This was an issue, I think, maybe at Costco, where workers wanted to have a chair to sit down on because they were standing for really long hours at a time. And in most states, there's not going to be any law that requires employers to provide that unless it becomes a disability issue. If you need a chair because you have a disability, that triggers the obligation to provide those kinds of accommodations. But if it's just because it makes your job easier, I mean, obviously the employer should do that, but they're not legally required to. So this issue sounds like she hadn't fully disclosed the potential disability when she was asking for a headset. So certainly if she were diagnosed with some condition and went in saying, I need a headset because my neck is messed up, you'd be entitled to that accommodation. But
Wouldn't we have an argument, though, to the extent she starts wearing a neck brace,
that they knew.
that then now it's disability related and they should come to her
And
talk
engage
with
in the
her
interactive
in the interactive process?
Yes.
Right.
Yeah. But employers love to just say, well, you didn't tell us specifically that you had a disability, so we're going to ignore.
How serious does the condition have to be a quote disability?
Yeah, it's a lot easier after the amendments. I mean, what clearly doesn't count as a disability are things that are very, very short term and very minor. So a cold is not going to be a disability that entitles you to accommodation. You know, the
The kind of
flu.
injury, the kind of condition she has where her neck is hurting would be enough.
Yeah, so she talked about how it impacted her ability to drive. That's a major life activity. There's probably other things that she's prohibited from doing fully. So I think I could, under the amended law, I think I could make a good faith argument that that's going to qualify as a disability, even if you haven't gone to a doctor and gotten an official diagnosis.
From the workers' comp perspective, my advice to this client would probably be to, if she has the means to do so, get a second opinion from a doctor of her choice. And if that doctor is supportive and says that, yeah, you have got issues going on in your neck, you've got carpal tunnel, and even possibly, you know, maybe a psychological consult if that's warranted, then we can really take those opinions, you know, and litigate the issue in front of the Industrial Commission if need be. So you don't have to just rest on the opinion that the occupational medicine physician has said. You can get second opinions if you're willing to pay for that out of your own pocket from your office. That's, you know, you can do that, or have the client pay for it out of group policy and try to get a solid opinion supporting the medical injuries.
I think we have 2 minutes left. I just want to quickly address the termination issue. So it came a week after she accessed her right to go to the workers' comp doctor. So that seems very suspicious to me. Also, she had disclosed the concerns about depression. So if you, and this is always something hard to do in all of our cases, but if you can prove that the reason she was let go was because her supervisor believed she had depression that might require an accommodation or leave, or just because the supervisor didn't want to deal with somebody with depression issues, that's a viable termination claim under the ADA. If she was fired because she accessed or attempted to access her rights to workers' comp benefits, that's the wrongful termination in violation of public policy. The fact that she was written up shortly before is not a helpful fact. It doesn't take away the potential claim, but it makes it more difficult because the employer is going to come back and say, well, the real reason we fired her, even though we didn't tell her this, because an employer is not required to give a reason when they fire you, was linked back to this, you know, disciplinary issue. But they didn't fire her for that, and a month went by without anything else happening, so her termination certainly seems suspicious.
Can the finder of fact imply from this temporal coincidence that they're not required to?
Yes. So almost all of the proof in our employment cases are circumstantial evidence. I mean, if you ever have
Smoking gun, then they're never.
yeah, those cases don't get litigated.
Very long.
Yeah, for very long, right. Okay, well, we hope you enjoyed our
I don't normally laugh at my clients.